Good morning and welcome to Privacy Conversations. My name is Daniel Solov. I'm a law professor at GW Law, and I also run a company on privacy training called Teach Privacy. I'm here with Justin Antonipillai. We do these conversations. We've had a number of them so far. Justin is with Wirewheel, and we'd like to chat with you today with Peter Swire. And I'll turn it over to Justin to introduce Peter.
Terrific. Hey, Dan, great to see you. Peter, welcome. We're really delighted to have you here today. And as Dan was saying, it's not only in the privacy community, it's not only in the security community, but probably one of the biggest issues that has hit the tech community for the last couple of months has been the Schrems 2 decision. And Dan and I are delighted to have you here today. Peter is senior counsel at Alston & Bird. He's a professor of law and ethics. I hope I got that right. Peter at Georgia Tech, very well known in the privacy space, and served as an independent expert on US law in the Schrems 2 case. And so probably one of the best experts on some of the issues that have really been coming up here. So Dan and I are delighted to have you here today. Welcome to our conversations, Privacy Conversations series, Peter. And let me just start. There's a lot to talk about. In fact, when Dan and I are out in the community, and I'm sure it's the same for you, we get a lot of questions. Obviously, I spent a lot of time working on Privacy Shield as well, and you and I collaborated a fair amount there. I read your posts and your writings regularly on the subject. I think they're just terrific. So we're going to talk about a number of different things this morning, but what I'd actually like to start with is, how did you get pulled into Schrems 2? And what was it like to serve as an independent expert on US law in Europe on these kinds of issues? So give us a little bit of color of what happened.
Great. Well, thanks, Justin, and thanks, Dan. I remember fondly when I had an office at GW Law School down the hall from Dan Soloff and Justin meeting you during the Privacy Shield talk. So I think the reason for selection was pretty simple at one level. I wrote a book way back in 1998 about Europe and the United States and data flows when the directive went into effect. And so I'd already written a book and worked on EU stuff. The book had an interesting title. It was called None of Your Business. And somehow Max Schrems has forgotten to cite that when he created his organization. But he knows about it. He just doesn't like to say it. But then I also was on President Obama's review group after the Snowden revelations, where we all got top secret clearances and did an investigation of the surveillance activities of the US government, issued many recommendations, many of which were later adopted. So, and that became a book published by the Princeton University Press. So I'd written a book on European US data flows. I'd written a book on US intelligence law. As far as I can tell, there was no one else who had written books on both those topics. So when it came to merging those, I was selected by Facebook, and under the rules for courts, once they hired me and asked me to do the testimony, they couldn't talk to me anymore. So I wrote this 360-page document that explains the history and practice of U.S. intelligence law, and that's what the testimony was.
That's really. I mean, were you able to collaborate with anybody else? Like, when you're serving as an independent expert in that way, you gather your own information, you form your own opinions, you file it with the court, and is there any collaboration you can do in actually preparing something like this?
Well, I had a great amount of help on research. There's a gazillion footnotes in it. And there were people in Alston & Bird working under my direction to write the testimony. And then one thing that got controversial is I then submitted the draft testimony to the US government, which shocked the lawyers for Schrems. And I did it to avoid criminal prosecution because I had all this top secret stuff for the review group. And you're not allowed to publish about classified material because you might get it revealed. You're revealing top secret information. So I was required by law to submit it to the government, which did clear it and which made dozens of very tiny corrections to make sure everything I said was correct. There weren't any material problems around classification. So if you call that collaboration, I didn't actually meet with them. I just got the comments. that informed the testimony.
Got it. Okay, and give us a little color here, Peter. So then you end up actually testifying. What was it like? What were the dynamics in the hearing, to the extent you could see it? What were the examinations like? Give us a little bit of a
I think it would have looked a lot like district court to an American lawyer. There was a judge, a woman judge, who was presiding, 6-week trial. I was on the stand for 2 full days. They were desperately trying to finish by Friday night so I could go home. It had been delayed, so I spent 8 days in Dublin, which is pretty good, but it was rainy.
Do you have a favorite pub that you found, Peter?
I at the time learned how to say schlanche or something like that, which is how you say cheers in the local language, but I've forgotten how to say it. But I did practice with Irish whiskey, so that was good.
Oh, that's a good one.
Yeah, and the lawyers wear wigs. There's the table for each of the parties. I stand in the box like an English movie, but also like an American movie, and it was really cross-examination for quite a long time, and for the data protection commissioner and for Schrems, and the judge asked quite a lot of questions. It was frustrating at the end because there was a lot of uncontested evidence that in my sworn testimony that the judge didn't address. So it was very frustrating where she reached conclusions that I felt weren't accurate to U.S. law in a whole bunch of respects, but she's the judge. And I think now there might be more action in the Irish courts looking at those factual findings and appeals now that we've clarified EU law. So one of the possible things is continued litigation in the national member state law courts. And another interesting possible thing that people haven't talked about more is there could be a Schrems type challenge in the UK. And if that was answered after Brexit, then the United Kingdom is making its adequacy decision, which might not be the same as what the Luxembourg court came out with. So we might have a new trial, new facts, new perspectives on some of that.
Yeah, that's really interesting. And any other color? Did you end up going to the high court hearings or any of that? Do you have any?
It was the high court. It's called the high court, what we call district court. I was not part of the litigation. Yeah. But one element of color is in the restrooms in the courthouse. They have blue lights, literally a color thing. And apparently the reason is so junkies won't shoot up because you can't see your veins under blue light. And so in the courthouse with criminal trials, they have blue lights in the restroom. So there's some local color, literally, that you asked.
That is literally local color. And did you end up going to the European Court of Justice hearings later?
No, I was not. I was out of the litigation. I wasn't writing briefs to the court. I wasn't eligible to go to the hearing.
Got it. Well, that's great. Well, look, there's a lot to talk about color-wise and next steps-wise. You have an article, and I'm going to turn this over to Dan for a moment to chat with you about. And then I thought I'd pick it up in a moment, Dan, on next steps, even under Privacy Shield. So, Dan, over to you about Peter's article.
Yeah, so I think one of the real big question now is what now? What do we do? What happens to Privacy Shield? Is there something that we can replace it with? How do we move forward? And I understand that you have an article coming out in Lawfare. I think it comes out today.
That's the hope, yeah. Right.
And with a possible path forward. And so I'm really interested to hear.
Yeah. Sure.
What's your idea?
So the article proposes one part of the answer, which is individual redress. And under European law, as Dan, you know so well, there's a tremendous emphasis that the individual have a meaningful review by an independent official, notably a judge. But that's been hard in the US because it's hard to establish standing for Max Schrems in the US courts. Where's his injury in fact? He doesn't even know if he's been under surveillance. And so the trick here is to start with a new statute. You could do it administratively, but it's better under a new statute. The statute would tell the agency, like the Director of National Intelligence or the Department of Justice or NSA, would tell the agency, you must do the following kind of investigation. And then the people with classified access go and do the investigation. Then it gets appealed to the FISA court, which is an Article 3 independent judge who's acting under US law, doing judicial review of whether the agency did its mandatory actions well or not. And a federal judge has the power to order remedies if there's a problem. And one feature that is you could say you have to comply with US law. Europe might not think that's enough, but you could negotiate an agreement with Europe where the standard also includes A, B, C, and D, and then violations of A, B, C, and D under that agreement become part of what the US government would be investigating if there's a request.
And so this is definitely something that would take new legislation. Is that right? We can't do this under the existing FOIA.
There's an argument that the agency could issue rules. The agencies could issue rules mandating investigations, and that maybe you could get Administrative Procedure Act review up to the regular district court. That might work. I think it's stronger legally if it's a new statute.
And then how would an individual get, redress? So let's say, Schrems, wants to know, is he under surveillance?
Right.
And they say, yep, you are.
No, you wouldn't say that. That's not how it works. It's not how it worked under Privacy Shield. Under Privacy Shield, basically the answer came back, either there was no violation or the violation has been fixed, so everything's okay now. And that, by the way, is how the UK does it under the Investigatory Powers Tribunal. Classified agencies are not in the business of telling people who's under surveillance. It becomes a game for the bad guys if you do that.
Yeah.
And so, but if you have a judge issue an order saying that he or she has found that there's compliance with the law, that's quite a major statement by a federal judge who's independent. And the answer, and by the way, if they can't make the statement, the judge won't issue the order. So if it goes by for a year and they haven't fixed it, then the judge doesn't issue the order saying everything's okay.
And then what would be the violation of? Because I know the FOIA standard when it comes to civil liberties such as First Amendment activity is one that is a bit narrow because it says it can't be solely based on First Amendment activity. So it's easy to cook up something to add to it that would make it fall out of that exemption. So a judge could look at a rather weak standard and say, oh, well, it's okay because they had, maybe 90% was based on First Amendment, but hey, there's a little bit that might not be. So ultimately, a conclusion that everything is okay only is as strong as how convincing and good the underlying standard is for whether or not someone's rights are being violated here. And obviously you would have to make a convincing showing to the EU that that's a meaningful test. So what would that test be?
And
do you mind if I interrupt just 1 second? Because I think Dan's asked a really, really important question, Peter. I always think it's helpful in the context of these conversations to step back just for a moment to make sure that for folks joining, we put a little context around the solution that you put on the table. So I'll phrase it briefly, but just to make sure, and then we can all react to it. Your solution is focused on one of the main things identified in Schrems 2 that was a focus of the court in invalidating the adequacy decision in Privacy Shield, on Privacy Shield. And if I understand it right, what you're getting at is that the European High Court said the Privacy Shield adequacy decision is not justified because when you're looking at the ability of a European data subject to get redress or independent review, and they phrase it within redress, get redress based on collection of their data in the US, by US intelligence authorities, but obviously for data in the US, when you're looking at redress, there were two things the court looked at that were used as justifications for the adequacy decision. They looked at the, number one, they looked at the ombudsperson role as it was constructed in the first version of Privacy Shield. And the court said, I'm doing it briefly, obviously, so I'm not trying to paraphrase. The court generally held that ombudsperson role doesn't meet the essential equivalence standard under EU law because that ombudsperson doesn't have sufficient independence and the ability to effectuate a remedy to meet the essential equivalence standard. That was one of their two things they identified. And the second major thing the court identified was that when it comes to seeking judicial review under current law for collection activities by an EU data subject for data that is passed to the US under Privacy Shield, that for that issue, the current standing law that are captured in decisions that Dan and I and you and I have talked about prevented an EU individual for bringing a lawsuit at the moment. And the combination of those two things called into question, in the High Court's view, the overall adequacy decision. And if I understand it right, what you're saying is your proposed solution to that is a new statute passed by Congress that is an analogous to FOIA and that carries those rights. Did I get that roughly right?
Yeah, that's right. And in particular, the court said the essence of the right under Article 47 of the European Charter, which is the right of judicial review, is to have that kind of independent judicial redress. And this provides that. Up until now, how to provide standing has been a real puzzle. And the Irish court was very upset about the lack of standing and thought it was an insuperable barrier. And the goal here has been to listen to EU law and listen to US law enough that there's an answer that could actually work under both legal systems.
Got it. Okay, so that's great. Now, with that context, did you, and Dan, did you want to follow up on the line that you were talking about?
Yeah, well, I guess then I think this could provide some standing, and ultimately, in the context of, the broader picture, there's also was another set of grounds that, as I read Schrems, that they were concerned about, and that is the fact that there's very little control when the government has data about people in its possession. You have the Privacy Act, but it's rather anemic and doesn't really work with surveillance and for national security. So ultimately, it seemed that the Schrems court was very concerned with the fact that there was nothing really to limit the retention of the data, to limit the use, all sorts of concerns over there. And I'm just wondering, to what extent could those concerns be alleviated? Because even if someone has standing to challenge, challenges it, and a court says, yes, this is legitimately gathered and it's not violating rights, it's still, it gets us part of the way there, but there's still this other objection. And then, so do you have any thoughts on, what happens then? Like, how do we solve that part?
Well, one part that has been sort of frustratingly not successful in the courts so far in Europe is to have an accurate understanding of what the US system does. So there's very clear either 2-year or 5-year retention limits for NSA data. And then people say things like there's no retention limits. And so that's just flat out wrong under publicly available legal materials we have about the United States. And so one of the answers is more transparency, although the US has more transparency than any other government's intelligence system. A second thing, though, is there was this proportionality overall. Is there enough control on surveillance? And there was the individual redress point. The individual redress point is a very specific point that didn't get solved by ombudsperson. And the hope with this proposal is, if you fix that one, you've shown good faith and you've also answered something you have to fix. And then you can at least have a conversation about the broader system. There's been the Strasbourg European Court of Human Rights decisions upholding Swedish bulk collection, basically upholding UK bulk collection. And the Court of Justice in Schrems ignored that whole jurisprudence from Strasbourg. So under European law, there's a lot of European law weaknesses. And in addition to that, there could be an appeal and ongoing litigation in Ireland about whether the trial court judge who did the hearing got it right on the findings, because she didn't respond to large amounts of the testimony and made findings that were contrary to uncontradicted sworn testimony. So lawyers are going to have a chance to litigate some of those other pieces, but you have to fix individual redress, or else I don't think you have a way forward to have a serious discussion.
Well, I definitely agree on that point. I guess I do find though that the attempt to kind of try to say or to analogize U.S. law to EU law, I guess I've always felt that that's not the real focus of the court, and even whatever might be said in the law about equivalent, it's not really that's not really what they're after. Ultimately,
That's true.
I think pointing out like, okay, EU, let's point out instances of surveillance in EU law. Let's point out problems in EU law that also exist in US law. To me, I just think that that's not going to be successful. And ultimately, practically, we really need to think about, the US law, and we need to meet a standard. Whether or not every country in the EU can meet its own standard is a different story.
I agree with that. Christina Irion, there's an article in the European Law Blog last week by Professor Christina Irion, Irion, who explains the European legal approach on exactly this point, and she agrees with you.
But I do think, Dan and I, one of my favorite parts about these conversations is we end up actually disagreeing, right? It's not all, I think you have to look at privacy as a human rights issue. And I think that's the part of this decision that so many people are excited about, that it's reaffirming that side of it. But I think you have to think about privacy as a legal issue. And we've been talking about the legal solutions here, but to ignore privacy as a political issue right now also, I think, has some real challenges to it. Each of the things we're talking about has political consequences to it. And I think it is totally fair, Dan and Peter, to put on the table when you're having these conversations, what about you? I mean, if we're going to have a real conversation about this, a lot of the solutions that we're going to get to will require political support, whether it's a solution, Peter, like you're talking about, whether we get to the point of having more of a treaty-based solution, Dan, that we've talked about, that is much grander. Even these adequacy decisions, fundamentally, they take, in Europe, for example, going through conversations with the parliament, with the council, with the member states. And I do think it's a fair point in the political context in which these take place to at least ask, wait a minute, what about you're examining only US in every single one of these? Where's your examination of data transfers to other parts of the world that people know are much, much more aggressive with far fewer human rights? There's none of that in the conversation right now, to be fair.
Well, no, but the Keneals announced it's looking at TikTok, and there are other DPAs who are looking at TikTok.
I agree.
China's going to be a focus of a lot more enforcement intention.
Yeah, I agree. And look, my point is not, just to be clear, I completely agree with Dan. If you go to the European High Court and your main point is, well, what about Europe? That's not their remit. That's not the way the legal analysis is going to take place. But I do think it's a totally fair conversation and part of the political issue to put on the table, hey, what about other parts of the world? What about the real, honest, essential equivalence? If you look at the collection and the protections in Europe, and what's going to happen in the UK with Brexit, if you have to do an honest political analysis and a legal analysis of collection and redress in the UK after post-Brexit, I think it's going to have political implications too. And that brings me to the next point that we were going to talk about in our short time here, which is there's the legal and the political solution. And Peter, I do look forward to your article. If you don't mind, when it actually comes out today, would you post it to
the link here in LinkedIn?
Yeah, so that our viewers can actually see it. I would love to have read it. I was hoping you would announce it and we can put it up today, but I know how that works. But I think it's a very thoughtful framework that you've put on the table, and I look forward to talking to you about it. And when you get something this thoughtful that could really move the conversation forward, it's important to look at it. But there is actually also the what next for Privacy Shield. And when I say that, let me make sure I'm putting on the table what I'm asking. So immediately after the Schrems 2 decision, which on its face says Privacy Shield adequacy decision is invalidated, and that decision is enforced immediately. Okay. The court also says for companies covered by Privacy Shield, look at the other derogations. And by the way, SCCs and BCRs are still theoretically available, but you have to look at additional protections. By the way, I just summarized the whole thing in about 3 sentences. There's a lot packed into that, right? Okay. Then you see the European Data Protection Board announce, hey, we're looking at these processes. We're going to look at different things. The question for everybody after that was, well, if I'm a Privacy Shield company, what happens to me? The Department of Commerce first issues guidance, just like when I was there, saying, by the way, we're continuing to enforce Privacy Shield. You can imagine an outside observer saying, what's that about? Why would you do that if it's invalid? So I'm happy to talk to that. But
accepted practices should be avoided. That's pretty simple.
Well, yeah, and to be honest, every Privacy Shield company is undertaking obligations to protect the data of those customers. And their customers gave you their data in exchange for that promise. Of course, why would you keep your promises? So I think it's a completely rational thing. Then you see, just in the last few days, the European Commission and the Department of Commerce announcing that they're reinitiating conversations to update Privacy Shield, which to me is a very, very encouraging thing, because I fundamentally believe that, number one, Privacy Shield, and I'm biased. Look, I was involved in Privacy Shield. I don't want to come in pretending
I think that understates it. Lived and died with it. Whatever.
Yeah.
Okay, right.
Well, thanks. And look, honestly, if I were coming in here and I was claiming to be unbiased like you were in the case, I don't think it would be fair. But I think it has the fundamental effect to me of getting a lot of companies, often smaller companies, to pledge to protect private data with enhanced protections and making public commitments about that and being fundamentally behind it in ways they may not be legally required to do so in the US. And that to me is an exciting, really important move forward, right? Because it gets the momentum going behind additional principles in a market-driven way. And it also puts us into a position that you don't want to wait to make progress towards privacy until you can have a grand global solution that may not come, in the short to medium term. A grand global solution may involve a treaty, or it may involve, international negotiations that are really hard to get to. So I do think making incremental progress every year towards the human rights and the privacy protection is critical. And to me, I was very excited, at least, that they're trying to update Privacy Shield, and that they're willing to take the political risk there. But from a political perspective, Dan and Peter, do you have a view on the chances of success or what the next steps are? And I'm happy to give you my perspective too. But Dan, Peter, I'll turn it over to you.
To me, it seems like you have two different tacks out of the EU. The CJEU is very principle-based, doesn't seem to me in a lot of its decisions to be that pragmatic. It articulates bold principles. There's a lot of implications of its decisions that it doesn't really trace down. It almost is kind of like an academic paper that doesn't really look at how it actually is going to work in real life. And I applaud them for sticking to their guns and sticking to their principles, but there's a practical side that I think should be addressed. But it does seem like the other DPAs, other regulators in Europe, the Commission and others are more pragmatic. They would accept the incremental change that you talk about as a big win. They will accept a kind of muddier, more compromised position that pushes the ball forward. But I'm not sure that the CJEU sees it that way. So I think to me, I see very different philosophies clashing in Europe, a kind of pragmatic side and then a very fundamentalist, principled side in this court. And I don't quite know enough about who wins that battle. But that's what I see going on as an outsider.
And just, there's some obvious things. So GDPR was failing in the European Parliament until Snowden happened. And then within a couple of months, they passed GDPR through the Parliament. And Schrems 1 happened in the wake of Snowden. And Europe right now is talking a lot about digital sovereignty, and there's a lot of anger in the EU that the current administration hasn't treated fellow democracies as well as maybe it's treated other countries. So there's a lot of anger at the US and also at the biggest US companies in Europe. So that there's a sort of digital sovereignty Europe needs to reassert itself side that's very important politically. And to the extent there are answers about in good faith, the US is coming back and doing good faith things on surveillance and on the way it's operating more broadly in Europe, that creates more room for the pragmatic side to win. And so I think these political forces will be very important. But then you also, at the end, have to have a workable legal answer. And so part of what Dan can work on and I can work on and others is going through the nuances of the law and finding the way through that can satisfy the legal standard. And then when it's obviously a better set of outcomes than the alternative, people in good faith can accept the legal approach that's being proposed. But if there's merely anger at the US for surveillance capitalism and surveillance NSA and the heck with them, if that's what's motivating the judges, it's going to be impossible to win. So you have to have more of a spirit of alliance and more of a spirit of shared values. The head of the European Data Protection Supervisor's Office said that US shares more values than China. He said that before the decision. There ought to be ways for democracies to move forward as allies. That's the big picture. And then how do we keep the conversation going as it takes time to develop that big picture answer?
Yeah, no, first of all, this is an area on which I agree with both of you. I think in the last round of Privacy Shield, the fact that ODNI and DOJ, with just phenomenally thoughtful representatives, came forward and just was willing to engage in the way they did and write up information and share what they could. Now, there's bans around it. Obviously, Peter, that you can't compromise national security. You can't share certain information. But the fact that they were willing to share and engage, in my view, was critical. The fact is, even now, on both sides, the teams that are actually coming together to work on this issue are just outstanding. I mean, I have enormous faith in the team on the United States side, and you can already see them trying to engage to gather information. I think writings from you and Dan and me, others like in the community, trying to share, here's some paths, are really important. It takes people thinking about it and making sure there's a fundamentally sound legal solution or politically legislative solution, that might be available that actually meet the requirements. And I think these writings and the way the community is working together is going to be important raw material. I also think we are lucky to have, in my view, very, very smart, thoughtful interlocutors on the European side, and they've been out trying to work within the language politically and the language of the decision to get out some ways that we can have paths under existing means of transfer like BCRs and SCCs and others, and also trying to give some guidance about where we can go on Privacy Shield. But having that path does give me more hope that one can have at least an updated Privacy Shield that will that might be available. And to Dan's point, I think no matter what we do, I mean, you could have 80, 90 different changes. It doesn't matter. One will always expect in the current environment that there will be another court challenge to an adequacy decision that involves the US. I think that's just going to happen, right? And I think that shouldn't prevent us from trying to make incremental progress and trying to move things forward, because I've never viewed the idea of a court challenge as stopping me. You just do the best you absolutely can, get the best solution you can, and try and move the ball forward, which I think we have a chance to do. But I think there won't be a solution that is insulated from a political or a court challenge. And I think court companies are fundamentally going to have backup plans no matter what you do.
And live with a certain level of uncertainty.
Yeah.
Which is uncomfortable. The lawyers don't have a slam dunk argument right now about why it's safe. And that's a very uncomfortable place for the lawyers and the companies to be. But I think that's the reality probably for a significant amount of time until there's further enforcement actions and more clarity from the courts in the EU.
Yeah.
No, and what about, in the short term, what about encryption? And I don't know how readily that could work, but ultimately encryption would be a safeguard that could allow it to go through BCRs and the contractual clauses. But I guess then the issue becomes, to what extent that could provide the full protection if the NSA could go after the encryption keys. So ultimately, if encryption could work in a way that would shield that could in fact be at least a possibility until a new privacy shield is worked around. I'm just wondering your thoughts on encryption.
Yeah, I think strong encryption solves 2 out of 3 problems the court flagged. So when it comes to underseas cables and access under Executive Order 12333, if there's strong encryption, then tapping the underseas cables doesn't work, and so there's no invasion by the NSA. First, the upstream part of Section 702, which is at the switch filtering many communications as they go through, strong encryption also shields the content against upstream, and so I think it's an effective safeguard for the upstream program. The gap is for the PRISM program, where a judicial order from the FISA comes down to a directive that says that the company must turn over certain selectors. And for that, encryption won't work because it's in plain text at the server. And so the companies that receive large numbers of 702 PRISM orders are the ones who have the least complete solution from encryption.
No, I get exactly where you're going, but I do think technical measures, to Dan's point, along with additional legal protections, are going to be things that all companies are going to be looking at.
Right.
And I know we've talked about this. It's very difficult, I think, for companies to be making public statements about how they're tackling these things right now for a lot of different reasons. I do know there's a lot of folks thinking very, very thoughtfully and very carefully about how they meet those requirements. I don't suspect we're going to see a lot of public declarations of here's how I solve the problem.
Can I just say a little bit on that? So the one reason companies don't want to say it is because they don't want to worry their European and rest of the world business partners. Another one is if there's going to be enforcement actions down the road, the company doesn't want to make an admission against interest that they're in violation of European law. Then they can't litigate in the enforcement action in Ireland or wherever it happens. And so there can be much higher levels of concern on the internal memos, but reason for the companies to try to say things are really okay. That's just the incentives facing companies who might face enforcement actions. And so the legal problems might be as hard as Dan's suggesting, but the companies haven't wanted to be in a position of saying that because it jeopardizes the enforcement actions that are coming at them in the next months and years.
And I'll tell you, we help companies right now deal with Schrems. We have customers on our platform, and we deal with this. And the 3 things we're working on, obviously, are you look at your standard contractual clauses and additional protections, and there are approaches, and it's interesting once you get into the facts that one can take. So we do have both approaches there and how you get your SECs in place, as a stopgap. You can obviously look at the derogations as a short-term fix, and we've talked about that. It's not a persistent thing you can keep forever. The binding corporate rules is another path, obviously, and we help with those. But it's an expensive process, and it's not clear, as you've seen from the guidance.
Yeah, the Data Protection Board questioned them as hard as they question contracts.
So to me, I don't know from my perspective, if you're under a BCR versus an SEC, to be honest, legally, there's very similar concerns you probably are looking at. So I don't know that that's a panacea. And then, of course, looking in addition to legal documented items, but technical items, exactly like Dan is saying, really understanding your infrastructure and understanding your service providers and who needs what can be steps one can take. And we're doing that every day. Look, I know we're getting to the end of our time together. I think we covered a lot. Dan, what do you think? Are there other things?
Absolutely. I think this has been really interesting, and I think there's definitely a lot more to talk about. I think we could go on for hours here. Maybe even if we could go on, maybe we'd actually solve it. But unfortunately, we're going to have to leave before it's fully solved. But that's a reason to tune in, because maybe in part 2 or part 3, we will get an answer. But I think it's great to know that there are really interesting ideas on the table. I'm really excited about your article, Peter, and look forward to taking a look and thinking more about this, because I think it raises a lot of fascinating questions and really challenging questions, just from an academic's point of view about, where do we go from here, and how do we address these issues, and then just practically, for companies, what do you do now? What's the long-term solution? What's even the short-term solution? I think all this is really opened up a really difficult set of issues that I think at this point, we're scrambling to come up with answers to. Thank you for joining us. This is really interesting, and be sure to check out Peter's new article. It'll be available today. And thanks again, Justin, for joining me in interrogating Peter on a really interesting topic.
Peter, I hope you'll join Dan and I again. I'm sure there'll be a lot more to talk about. There's a lot coming up in the next few weeks. And for everybody joining our normal privacy conversations, Dan Soloff from Teach Privacy and Justin Antonipillai from Wirewheel. Peter, look forward to talking to you soon.
Great. Good luck to everybody on this hard problem. Thank you.
Thanks.
Thank you.